So, Ms. Davis, the department has announced ready for trial.
Yes, Your Honor.
Thank you. And so, Ms. Hollier.
Your Honor, first, I would like to let the court know that I have filed a motion to extend the dismissal date, let all the parties know, and filed that ahead of today's hearing. With regard to the trial, I am announcing not ready. I received the redacted records disc about a week and a half ago, and it's fairly lengthy, and I was under the impression that we were stuck on the Tuesday docket with cases, and then learned that it was being moved to today. I have had the opportunity to review the records because I learned that the Oaks case may not be as long today because of the developments that you heard. And so I assumed the Oaks case was going to take most of today. But so I did, in fact, were able to review the redacted records. They only go through January 12th of 2023. So I don't have all of the narratives that I think are necessary, as well as some of the testing that's been done. I did get from Ms. Davis prior to court the latest testing on my client. And I was also able to talk to Ms. Davis yesterday after hours, which I do really appreciate her giving me her time. As the court knows, there's been lots of removals in lots of counties, so I'm doing the best I can. But Ms. Davis was able to tell me the witnesses she plans to call, and that the department is in fact ready to go forward. I'm asking for number one, for the court to hear my motion to extend, and then secondly, ask the court to give me time to get the department to give me the rest of the records and allow me to be able to talk to my client about what all the evidence is. I was able to talk to my client fairly lengthy yesterday evening, but we weren't able to get into the actual evidence. It was more of a conversation about her risk of going forward with the termination trial. I don't know if Your Honor is aware, but she has had another child. The parents have had another child, and there's a subsequent case in another county. So I felt definitely that should have been my focus on my conversation with her yesterday. So I'm asking for the opportunity to have the full records, to be able to have time to go over the evidence with my client if the court is not so inclined to grant her an extension of time. And I'm not asking for a long reset. I just want the opportunity to have all that ready to start trial.
All right. And were the court to entertain your motion for an extension, which I am, what, if anything, would you add to that?
Well, that I'm unable to be ready in order to give my client the best defense, because I don't have all the evidence from the department. Not that I don't believe we're trying to keep the evidence from me. I just need it in full. So I include in my motion that extraordinary circumstances should include the fact that I don't have all the evidence ready to for me in order to proceed with a defense in her case.
Okay, so I think your contention is you might be missing about 6 weeks worth of records.
Very relevant records, because my client has done, I believe, quite a bit in that amount of time. There's also the issue with the courtesy workers. So Ms. Daniels has definitely made me up to date on everything. The difficulty is I have not had a chance to talk to the courtesy workers in conjunction with what I'm reading in their narratives, and telling my client what their positions are going to be at trial. So it's not sought for delay, it's just sought so that she can have a fair defense.
Okay, does another county have custody of the newborn?
Yes, sir.
Has the adversary hearing occurred?
It has.
Okay.
And the child is in placement and the mother is working service plan, is my understanding.
Okay. All right. Ms. Davis, any idea how long it may take to supplement the records?
Honestly, no, Your Honor. With the number of weeks being so little in respective to how long the case has been going on, I don't imagine it would take too long. But I honestly do not have any sort of time frame that it will be available. But that would be something we would be requesting be immediately happening if the court were not to proceed today.
Okay. Next time I ask that poor question, just say ditto. It's not really a fair question, but yeah, okay, all right, I get it. Thank you. So let me hear responses, announcements / responses from Mr. McCatherine, Ms. Moore, and then Ms. Davis.
Your Honor, I would ask that you call for my client, Mr. Kerr, to see if he is present.
All right. Yeah, thank you, Mr. McCatherine. So the mother, Sheena Sweeney, if you will answer, ma'am.
Yes, sir, I'm here.
Okay, thank you. I have you marked present. All right, now calling for the father, Britton Kerr. Okay, Ms. Moore.
Judge, I am ready today. As to the motion to extend, I am opposed to that. We're talking about 6 weeks of records. Whenever we come back, which I think it will probably be difficult for us to find a time since we're going to be in person. So then at that time, are we going to be missing let's just say if that's in 4 weeks, are we going to then have the excuse that we're missing the 4 weeks between now and then? She said that she believes that her client has been working services during that time and that the department has been able to turn over results of drug tests. So she's got that. The only other service that I'm aware of is therapy. She knows the name of the therapist and has had the opportunity to call and speak to that person. If there's other services that her client has done during that time, then her client can provide her that information. I don't have a problem if she wants to take some time today in a breakout room to really talk to her client more about it, but pushing this case farther and farther along, I do not think is in this child's best interest.
All right, thank you, Ms. Moore. Ms. Davis.
The department would be in the same line as Ms. Moore. We would ask that the extension be denied. I believe that Ms. Daniels has been forthcoming with Ms. Hoyer about the information of their most recent services that Ms. Sweeney may have completed. But up until this point, I believe an extension will just is a delay tactic, and that she has been given the opportunity to work and complete these services. And up until this point, it has not been completed. So we are asking the court to deny the extension and allow us to proceed today.
Your Honor, I'm not sure that I gave my announcement previously.
I think you're right, Mr. McCatherine. So you may at this time, please.
Your Honor, at this point, I would have to announce that I am not ready for today. I have not had an opportunity to meet with Mr. Kerr. As you may know, Mr. Kerr has been in the Jefferson County Jail since June of 22. He has appeared periodically during this case. I followed the normal protocol by notifying the Jefferson County bookend by email. I did that on Monday at 4:54, copied Ms. Davis and Ms. Daniels to let them know that I had taken care of providing the Zoom login, requesting for Mr. Kerr's attendance at our trial today. This is a termination trial, or a trial to forever terminate his parental rights. I feel like he should have the opportunity to be present for that and to consult with his attorney maybe in a breakout room prior to. And I'm not sure exactly why he is not on today. I would ask for a reset and an order to appear since the jail is now not, I guess, is not following the protocol of submitting the email with the Zoom instructions as we've used previously in the past.
All right, thank you, Mr. McCatherine. Do you all agree that the dismissal date is March the 6th?
Yes.
Yes, Your Honor.
Yes, Your Honor.
May I say a few
Yes,
more things, Your Honor?
of course.
If the court is inclined to extend this case today, the department would just be asking that we be allowed to commence on the merits and reset to allow time for the redacted records to be prepared, but not to extend this case any further, as that's not in the best interest of the child.
Well,
And I'm sorry.
I would say, unless somebody can change my mind with probably the next 60 seconds, I'm inclined to commence on the merits. I'm not inclined to give a general extension.
I understand, Your Honor. I understand that. I'm clearly asking for enough time to review the records. I don't believe this is a delay tactic. This is not my style. I don't come to court every time there's a trial setting for my client to ask for that, but this is a termination trial that means a lot to my client. And the fact that I got it 2 weeks ago and only knew yesterday that it was for sure gonna go today, I think that I deserve that time to review all the records and review them with my client and get ready. And I don't, so I am, if the court is not inclined to give my client an extension of time, I'm asking for the commencement to be short and give me some more time to have those narratives. They're important and they're not always exactly what the caseworker says they are. So I need them in her defense.
Judge, may I comment as to the start and stop?
Well, as to commencing on the merits, you may, and I need to get Mr. McCatherine's view on that as well.
As to starting and stopping, I don't believe that Mr. McCatherine's client not being here is a reason. This is a double negative. I don't believe that that is a reason not to start the trial. I believe there's case law that states that. Additionally, I would be okay with a start and a reset today, only if we were able to come back very quickly, you know, not
Okay.
30, 60, 90 days.
Okay. Well, I need to ask you something, Ms. Moore, before I get any more into the weeds. Okay. I don't mean to imply that I believe we can have the records by then.
And I don't understand why, if it's just 1 month of narratives, that the department caseworker or her supervisor can't redact them and get them to me instead of having this long delay. It shouldn't be that hard, so that there isn't a long delay. Because Ms. Moore is exactly right. There's always going to be a little more, but I do believe the last 6 weeks is important. And I just didn't know if internally CPS could help with that. Mrs. Davis has always been good about turning over. She's the one that sent me the drug test this morning.
And one more thing, Judge, to that, if we're going to start and reset, if it's possible to get a court order today that the mother submit to a hair follicle and or a fingernail test today, that would be fantastic.
Well, and I'll just add that in the other case, she's also undergoing hair follicle testing that I was attempting to get from her other lawyer. So I don't know how long ago she's had one, but I just want to let everybody know that. But I have no objection to Ms. Moore's request.
Okay. All right. So the court will then order um, a hair follicle test, or in the alternative, a fingernail test, and a urinalysis of the mother by the, well, we're in a, is Ms. Robertson the courtesy worker by any chance?
I think so.
She is, Your Honor.
Okay, so Ms. Robertson, what is the soonest we could get the 2054s in place?
Judge, it is 3:28 now. I can issue it as soon as we're done with the hearing, but I can't guarantee I can get it approved by today. The latest, I would say would be, I can do my best to get it done right away.
How about, and I know you will, and thank you for that. How about we say go ahead and do all that you can do today, but how about we say mom needs to go by the end of testing time Monday?
Judge, my concern with that is you've ordered hair and you've ordered a fingernail this entire case and it's never been submitted to.
I'll order her not to alter it.
My concern is just giving her time to cut her nails or to alter her hair. It kind of defeats the purpose of it being random.
A hair test isn't, I think she's just recently had a hair test and she just had a UA on the 23rd. So, I mean, I don't know.
Judge, may I interject?
You may, because I assume the place only tests another 45 minutes or an hour at the most anyway.
The problem that I have is there's a location directly, well, not directly near Miss Sweeney's home. It's maybe less than 5 minutes, but the problem is the constant refusal. She won't do them. She'll go for the UA, but she won't do the hair.
Okay. All right. Well, her lawyer can explain to her what a court order is and what not following that might mean. So I will, within that order, order her not to alter her hair nor cut her nails, do her nails before the tests by the end of testing Monday.
Okay, and I will get it issued today.
And so, Your Honor, my biggest, I guess what the other thing that I need is this last 6 weeks, if that's in fact the facts, me having those facts or any of the drug testing would be very helpful starting trial. So that just, I think, adds to my point that I need this information.
Well,
I mean, my client, I need to be able to talk to my client about what the recent evidence is if I'm going to get her to understand the risk.
okay, that would be ideal to have, but if we're just, I mean, even commencing on the merits, but if we're just merely commencing on the merits, but legitimately commencing on the merits, we may not even get to drug testing.
Sure. Yes. No, I'm just making yes, I agree with that. I'm just making the statement that that's why I need it. But I'm comfortable with if the court is going to force us to commence on the merits that would not we wouldn't get that far into it. But I really would like the information before the next time we restart. If that's possible.
You use the word force. I didn't use that. Are you not amenable to commencing on the merits today?
I'm still pleading my motion for extension, Your Honor.
Right. The motion for general extension is at this time denied.
Okay, then I am. I'm sorry.
No, go ahead.
Then I'm announcing not ready, Your Honor, and asking for more time. Based on all the statements I've made previous.
Okay, thank you. In addition to the drug testing just ordered, the department is going to, the court's going to order the department to produce the supplemented redacted records since January the 12th of 2023.
Can we throw in the word expedited?
Yes. Yes, we can. All right, with that, we are still on the record. The court is going to deny any request, any oral motion for continuance. We are going to commence the trial on the merits. And in the meantime, I will be looking at dates probably no earlier than the last week in March. So you all know we would need to get this done within 90 days.
Could we possibly take March 6th since
I
the
have,
other one will be moved?
I have a court-ordered mediation scheduled March 6th.
Yeah, the records won't be back then.
Well, I was thinking if they just printed and redacted themselves, it could be earlier.
Which I'm totally fine with.
What about the 14th?
That's, I think that's just a little somewhere between unreasonable and onerous right now. I mean, to do that by the 6th. Everything I have in part because of the Advanced Child Protection Law Conference. I don't have anything meaningful until the last week in March.
What days do you have, Judge?
28th through the 31st.
I'm available.
I have the 28th and the 29th, and of course, you know, the 30th, I usually have CB at Orange County, but if I'm in trial, so.
Okay. Thank you. What about you, Ms. Davis and Mr. McCaffrey? Are both of you available? All four of you available on the 28th?
I am.
Yes, Your Honor.
All right. So,
Question,
sure. Is it in person? Yes.
if it's in person, is it the hybrid version? And how would I have my client appear in that event?
Okay. Take a look at the letter. I trust that you got it about going back in person. So I'm going to continue to schedule these on Zoom because the reporting is going to be done virtually, remotely.
And Your Honor, asking that because I know we have a courtesy worker, can professionals also appear via Zoom if that is, for example, counselors, stuff like that, if we ask ahead of time? Is that also included in our request for good cause?
It can be, or you all can just agree and stipulate to that.
Okay.
Okay.
Because I know most of the providers that she's with are
Right.
virtual or not in this region. And I know Miss Robertson is not either, and I'm not
Okay. Okay.
expecting her to come down, but I would like her presence in case I want to call her. And I know Miss Davis said she would work with me on that as well.
Okay. All right. Now I do, and I think you understand, I do want your client in person.
Yes, I plan to be in person, and I've already told my client that if this did not proceed and finish today, that the court is going back in person. So I agree with you, Your Honor.
Okay. So, Mr. McCatherine, you seem to, was your wincing about the 28th, was it about appearing virtually for your client, or did you discover a problem with the 28th?
I am completely free on the 28th, Your Honor. I was just thinking of how to implement with the new rules, if it would be easier for me to appear remotely where I can meet with him privately in a breakout room or such, as opposed to me being present in the courtroom with a client that's virtual. I guess that's just me thinking out the semantics and the practicality in my head, my wincing.
You know, that's a very good point, because you being in the courtroom, you sort of kind of obviously he's not there next to you, And you sort of also lose the ability to go into a breakout room. So, so think about it. Just shoot Ms. Wallingford an email copying everyone, and I think I would find good cause for you to appear virtually as well.
Excuse me, Judge. Quick
Yes,
question. The court order, is it for hair follicle or fingernail?
it's for,
Judge, can I request a fingernail in lieu of a hair? And
Yeah.
then I think give her until close of business on Wednesday because it will take that long for them to get the 2054.
Okay, that's why I was asking. It may take a little longer because it's a certain process that has to be done. And it has to go through several hands before I can actually get an approval to get that request done. That's why I'm asking for
because
the fingernail.
because it's a fingernail.
Yes, sir.
All right. Okay. So yes, I will order a fingernail test
Okay.
in lieu of a hair follicle test, but also a urinalysis. And I will make the date by which to submit to those tests. Wednesday, the 1st, by the end of testing.
Okay, I understand.
Okay, Judge, being that it's 3:42 now, I don't know that I can get that request over to the initial person for today to begin the hair follicle test. I don't know if Wednesday is going to be feasible enough time, if I'm being honest.
Do you mean the fingernail? You said
For the
hair.
fingernail test, it's because it's a closed contract. I have to have the 2054 open, that it has to be open in our system. I have to get the approval to open it, and I have to have the court orders first. And then once I send everything over, then they open it. I request it that I have to have them close it, send it over, and then they have to send it over to get the approval over to the location to get it done.
Could
Okay.
we maybe say like within 24 or by close of business, the morning that the department lets her know that it's ready and she needs to go test?
What's your work schedule, Ms. Sweeney?
Well, I work from home, so I can go do it. Wednesday or Thursday would be okay.
Okay, all right, thank you. So, Ms.
Thursday I'll be in Hardin County though.
Okay,
For visit, Your Honor.
okay, good, good. Ms. Moore, what was the time frame by which, once she has notice from CPS?
Just by close of business, the day that they request her to go. That way, if they know they have it in line on Friday, they could message her Friday morning and say, hey, submit today, and she needs to go by close of business that day.
Okay, I will order that, so long as they must at least provide her a 4-hour window.
Most
Okay.
definitely.
Yeah,
And does the order to not alter her nails remain in place?
that does. Let's make sure that's in there. Yes. Yes. So again, no hair test, Ms. Robertson.
Okay.
But fingernail test. No altering of the nails whatsoever. And I don't know if Mom can send Ms. Robertson a picture of her fingernails right now or something like that. I don't know. You can go by and look at them, how that might be verified. I don't know. I'll let you figure that out. But also a urinalysis.
Question, sorry.
Go ahead, Ms. Sweeney.
If I'm in Hardin County and she orders it for Harris County, what do I do? Like on Thursday, I'll be seeing the babies in Hardin County.
Well, I don't know what time your visit is, or you're in Harris County, is that correct?
Correct.
Okay, all right. Well, so as not to conflict with the mother's scheduled visit on Thursday. So long as it does not conflict with that. Okay.
Judge, this might seem odd, but is it possible she could go ahead and show her nails now?
Okay.
In my hair. Did you see?
Okay, so Once again, both of them, Ms. Sweeney, if you don't mind, can you all see an enlarged, just the speaker screen? Or are you all still gallery?
It's gallery.
Oh.
for us.
Judge,
I mean, that's how I
We
see it
can-
as gallery.
I can change it to speaker if she'll just be willing to show it again and speak.
Oh, can you see?
Go
Says-
ahead, quickly.
I can see them, but they look, to me, they look extremely short. I can't really
They're
tell.
always short.
Would the court give me permission to take a screenshot of the image of her showing her nails so that we have evidence of that?
Any objections, Ms. Hollier?
Yes, objection. I mean.
All right, so I'll that was,
I mean, I think that Miss Sweeney knows that if she alters her nails or cuts them so short, and knowing that the court has ordered this when it might not be till next week, then she's got a problem. So just hear that, Sheena. Don't cut your nails, even if you get dirt underneath them. Let it look raggedy so that they have something to cut, okay?
Yes, ma'am, I will.
And if they're so super short when you get there, and that's what the testing facility says, Miss Moore is gonna have a problem with it. So be ready for that, okay?
Yes, ma'am.
And probably everybody else, but Miss Moore will definitely tell you she has a problem with it.
Yes, ma'am. I won't cut them.
Okay.
all right, but that was clever, but I'll deny it. So,
Okay, thank you,
okay,
Judge.
so let's continue with our commencing on the merits. Does everyone agree to defer any opening until the 28th or your case in chief?
Yes,
I
Your
would
Honor.
agree to that.
Yes, Your Honor.
Right, thank you. So, Ms. Davis, let me know whom you're going to call, and I'll just swear that individual in.
I'm gonna call Mark Vincent.
Okay, actually, Mark Vincent was in the waiting room.
I believe he's in the courtroom now, Your Honor.
I think I'm in here. I'm not real sure how this works.
Okay, well, how court works or Zoom?
No, how the Zoom thing works. I'm kind of new to
Thank you
this.
very much, Ms. Davis. You may proceed.
Mark, are you able to connect to video?
I'm giving it heck right now. Let's see.
Okay.
I'm going to ask you to start your video, and let's see if that.
Oh,
Oh, yeah. Okay, that did it. Whatever you did.
Perfect. All right. May I proceed, Your Honor?
You may. Yes.
Mark, can you state your name for the court?
Mark Vincent.
And how are you currently employed?
I'm the lieutenant supervisor over the Hardin County Special Assignments Unit.
And how long have you held that position?
I've been here for 18 years. I've been a lieutenant for 5, I believe.
Back in February 14th of 2022, were you still a part of that same unit?
Yes, ma'am.
And as part of that specialized unit, what are some of your routine daily tasks that you perform?
I investigate narcotic-related offenses, gang-related offenses, major crimes. Well, anything that the sheriff would deem special.
Are you a licensed peace officer?
Yes, ma'am, I am.
And are you in good standing with TCOL?
Yes, ma'am, I am.
Referring back to February 14th, 2022, did you have the opportunity to do a surveillance in Sour Lake, Texas?
Surveillance, yes, ma'am.
And what was the purpose of that surveillance?
I believe Mr. Kerr had active warrants, Britton Kerr, had active warrants out of possibly Jefferson County, and we were tasked with the assignment of trying to locate Mr. Kerr.
And is that a residence that he is known to frequent?
Yeah, it is. It's his mother's residence, his brother's residence. That's where he stays when he's not in jail.
And so on February 14th, what did you observe?
While doing surveillance, we observed, so there was a car parked in front of the residence. The residence is a trailer home that sits parallel to US Highway 105. The vehicle was sitting in front of the residence, also parallel to the road. It was facing, I believe that would be westbound. And this was right at, it's starting to get dark. We could see some movement and some in and out in the car. Then we started seeing some brake lights on and off in the car. Then we observed the vehicle leave the residence. We were able to tell that that was actually the vehicle that we had a description of that Mr. Kerr was operating. Once we saw the vehicle leave the residence, we left our secure location, drove up to Highway 105. When the vehicle left, it went westbound away from the Beaumont area towards the Batson area. We got on 105 and we went westbound also. It took us a little bit due to the fact that we were in a concealed location. It took us a second to get, our vehicle in order, get out on the highway and pursue the vehicle in hopes of detaining Mr. Kerr. As we were exiting, we observed the vehicle down 105 doing a U-turn and coming back towards us. Once we observed that, we got on the side of the road and waited for it to pass. We did a U-turn, followed it back to the residence and pulled in behind the vehicle at the residence.
How far, if you can tell the court, how far down did the car travel before making the U-turn?
I'd say a mile or two, maybe.
Okay. When you pulled in behind the vehicle at the residence, what did you do after that?
Pulled in behind the vehicle at the residence. We exited pretty expeditiously to try to get on top of the vehicle. Mr. Kerr does have a history of running from us, so we try to get on top of him pretty quick. We approached the vehicle. Mr. Kerr was sitting in the driver's seat of the vehicle. The white female was sitting in the front passenger seat of the vehicle.
Was there anyone else in the vehicle?
No, ma'am.
Ultimately, did you identify the female passenger?
I did. It was Sheena.
Was Mr. Kerr taken into custody at that time?
Immediately, yes, ma'am.
Did at that time, did you have to make a call into CPS for issues?
Objection leading.
Was there anyone? Sorry, Your Honor. Based.
I'm sorry, I sustained it. You may continue.
Thank you, Your Honor. Did you have a conversation with Sheena?
Yes, ma'am.
And what, if anything, of significance came from that conversation?
At that time, she wanted to return inside the residence. I believe it was to get a jacket. I don't remember the exact details of why she was wanting to return inside the residence. Based on the fact that we had already had Mr. Kerr in custody and we were in a safe environment, and I had another officer there with me to maintain contact and control of Mr. Kerr, I did allow Sheena to enter the residence as long as I was able to go into the residence with her to ensure that she wasn't in the residence for any
Objection non-responsive.
Sustained.
Did you go with Miss once you allowed her to enter the residence, what did you do after that?
I went in the residence with her.
And what did you observe?
I observed the baby in one of the bedrooms of the residence in a bed.
Was there anyone else in the residence at that time?
There was not.
And how old did the baby appear to you?
Newborn.
Okay. Did Sheena respond in any way about having her infant in the home alone?
I asked her if there was anybody else in the residence. She said no. I said, you left the baby here by yourself? And She said, yes, but it wasn't for very long.
Okay. Did you identify anything else in the home?
Not to my knowledge that I can think of off the top of my head. I'm having issues with my system right now, so it's not letting me access my reports.
Okay. Did you so are you doing all this based off your memory?
Yes, ma'am.
And based on the specialized unit that you work for, do you routinely have wear body worn cameras?
No, ma'am.
Does your vehicles have dash cameras?
No, ma'am.
So for this case, are there any video footage of this interaction?
No, ma'am.
After seeing the baby in the home alone, what did you do after that?
I contacted Child Protective Services.
And did someone report out there?
Yes, ma'am.
Does that conclude your involvement regarding the child that you found in the home?
Yes, ma'am, it does.
I will pass the witness.
All right, thank you, Ms. Hollier.
Thank you, Your Honor. Is it Officer Vincent or Lieutenant Vincent?
Either's fine.
Okay, I didn't want to call you by the incorrect. How are you? My name is Bonnie Hollier, and I represent the mother in this case, Sheena Sweeney. Okay.
Yes, ma'am.
So I had requested. Did you testify at the adversary hearing, or was it your partner?
Say again?
I can't recall. Did you testify at the adversary hearing in this matter, or was it someone else? I can't recall. I know an officer testified. I just wasn't sure if it was you.
I don't believe it was
Do you
me.
recall?
No, ma'am.
Okay. Okay. I didn't think so either, because you said you were fairly new to Zoom and it probably would have been on Zoom. So I had made the inquiry prior to the adversary hearing a year ago when this case was brought on video or dash cameras. And I was told that there weren't any. So my question to you is why isn't it normal for law enforcement to have body cameras on them, or why did that not occur during this incident? I guess is what I'm asking.
It's normal for patrol officers. We're not patrol officers, we're detectives. We're a specialized unit, and part of that unit is we're not equipped with that.
Okay, so the particular unit, and I'm gonna go back, the particular unit that you were doing is more like surveillance work in order to apprehend fugitives and bring them in, not so much policing and trying to get information to get a warrant. Does that make sense?
No, we're 100% law enforcement. We do everything from complete investigations to high-end murder cases to surveillance cases, whatever we're called for.
Okay, and so that's kind of my question. If you are involved in investigations, how are you not equipped with body camera or video in order to do that type of surveillance? Or in this particular case, was it not needed because you were just trying to apprehend someone?
So there are stipulations of the law that dictate what officers are required to wear body cam footage, and there are certain officers that are not required to wear body cam footage. I fall in that category of officers that are not required due to my job description and details, and nor have I ever worn one.
Okay, and so that answers my question. Who were you with on that day? With an officer? Were you with a partner or?
Yeah, that would have been Sergeant Jesse Orr, I believe.
Jesse, I'm sorry.
Jesse Orr.
Orr, O-R-R?
Yes, ma'am.
Okay, so is he also the type of law enforcement that is not required to have body camera or video?
Yes, ma'am, he is.
Okay, so neither one of y'all is a normal practice of business for your particular job skills to do that, correct?
Yeah, no, ma'am. No,
All
ma'am.
right. Now, when you're doing the surveillance work, I assume you're not in an active patrol car that says, "Look at me, I'm the police." Is that accurate?
We are in a county issued vehicle equipped with lights, sirens, radios, PAs. The only difference is that we are not visibly marked from the exterior of the vehicle.
Okay, so in those county issued vehicles, are those not equipped with video?
Ours
cameras?
are not, no ma'am.
Okay, so it's not the same as a patrol car where when lights come on, the video automatically comes on?
No ma'am.
Okay. At this time, I have no further questions for, I believe, I hope it's Lieutenant. I don't want to be disrespectful. Lieutenant Vincent.
Yes, ma'am.
But I do reserve the right to recall him in my case in chief, and I would ask that he not be released and that the department work with me to obtain his presence at trial when we reset.
All right, thank you, Mr. McCatherine.
I have no questions of Lieutenant Vincent at this time.
All right, thank you, Ms. Moore.
Lieutenant Vincent, my name is Lori Moore. I'm the attorney for the child, and I may have missed this or misunderstood it. When you approached the vehicle and you saw a female in the passenger seat, how did you identify her?
I believe that was actually my partner on that side of the vehicle. I was on the side of the vehicle with Mr. Kerr. And I was able to visibly, through my past experience in dealings with Mr. Kerr as a narcotics officer in this county, I was able to visibly to identify him on sight. I'm pretty sure my partner, who's Sergeant Orr, was on the passenger side of the vehicle and made that identification.
Okay. Prior to entering the home with Sheena, she didn't express any concern about there being a baby in the house, did she?
No, ma'am. It was a surprise to me.
Okay. And when she got out of the car, she didn't appear to be frantic as if she was taken against her will, did she?
Objection,
No.
leading.
Overruled.
I
No,
didn't hear
ma'am.
that. Okay. She didn't actually say anything to you at any point that she was just sitting in the car and it was Mr. Kerr who decided to drive off, did she?
Say that one more time, ma'am.
She didn't actually say anything to you that she wasn't intending to leave. It was Mr. Kerr that made that decision, did she?
No, at one point while speaking with her, she did say that I was just sitting in the passenger seat. We were arguing and we were he drove off and we were gonna talk.
So he drove off so that they could talk. Is that what you mean? Or
Objection asked and answered and misphrases the testimony.
Overruled. You may answer.
can you explain more on that? He drove off and we were going to talk. Did she expound on that? What was your impression of that?
I mean, she was in the passenger seat. Mr. Kerr was driving the vehicle. She did state, and like I said, at one point, she did state that Mr. Kerr was the one that was operating the vehicle, was in charge of the vehicle at that time. They were in some sort of argument. Based on that argument, they were going to go talk. And then Mr. Kerr is the one that left the residence. And that was basically the end of that.
She didn't ever tell you that she didn't want to leave the residence?
Objection asked and answered.
Overruled.
I don't recall that.
She didn't ever express to you any concern for the baby being left alone when Mr. Kerr drove off, did she?
No, ma'am.
She didn't express to you that she had any issues at all with the baby being left alone, did she?
No, but she didn't even, I guess, address the baby until after I discovered the baby and made it apparent that I was going to have to get Child Protective Services involved due to the fact that the baby was left alone. And at that point, she started to try to establish a defense.
Okay. When you went into the residence, where was the baby located in relation to walking in the front door?
Objection asked and answered.
Well, overruled as to that specific question.
The baby was located in a rear bedroom on the west side of the trailer when you walk in the front door to the left.
Pass the witness.
All right, thank you, Ms. Davis. Back to you.
I have no further questions for Lieutenant Vincent at this time.
Thank you. Any other questions from anyone for Lieutenant Vincent?
Yes, Your Honor, briefly.
Okay, you may.
Lieutenant Vincent, based upon the time that you were observing and you saw the vehicle leave, do you have an estimate of how long the child would have been alone in the trailer?
Well, to answer that question, I guess I would have to evaluate a little bit further that they were outside the trailer sitting in the vehicle for quite a while before they ever even drove off. We didn't approach the vehicle while they were in the vehicle due to the fact that we weren't sure if he would bail on us from the driveway, but they were in the vehicle, sitting inside the vehicle for maybe 10 minutes, 15 minutes. And then they left when they drove away from the residence, maybe 4 minutes. Like I said, I think they pulled out, they probably made 1.5 miles down the road, pulled over, and then did a U-turn.
So your best guesstimate would be 14 minutes the child was unoccupied?
I would say a 15 to 20 minute time frame.
Okay. Because you told us 10 minutes outside talking and then 4 minutes to drive the 1.5 miles down the road.
10 to 15 minutes outside talking. Correct. And about 4 minutes on the road.
Okay. And when you went inside the residence with Miss Sheena, how did the baby appear to you?
Yeah, laying in a bed.
Did the baby appear to be harmed?
No, ma'am. No, sir.
Did the baby appear to be in distress?
No, sir.
Did you observe anything unnatural or unnormal or alarming with that child?
It was pretty alarming that they drove away from the residence and the baby was alone at the residence.
But physically looking at this child, was there anything wrong with the child?
Oh, the state of the child and no,
Yes.
sir.
Okay. Thank you, Lieutenant. I'll pass this witness, Your Honor.
All right, thank you. Any other questions from anyone for Lieutenant Vincent?
Just briefly, Your Honor.
All right.
Lieutenant, why did you feel like it was necessary to call CPS?
Well, as a father, I would never leave my newborn child alone in a residence while I drove off to have an argument.
I'll pass the witness.
All right, thank you. Any other questions from anyone for Lieutenant Vincent?
I have one.
All right.
Was it concerning to you that these parents left the child alone for 10 to 15 minutes in the car while they argued?
Objection asked and answered. He just answered that.
He said leave.
Sustained.
Okay, pass the witness.
Okay, anyone else?
No, I just still again reserve my right to recall him and ask that the department help me make him available.
Okay, thank you. All right, so Lieutenant Vincent, thank you very much for your time, your patience, your assistance this afternoon. I'm going to let you go, but you will be subject to recall.
Subject to recall today, sir?
Not today, no, sir. At
Roger that, sir.
least not in this court.
Roger that, Your Honor.
Thank you. All right.
Thank you, sir.
For your excuse for today. Thank you. All right.
Thank you, sir.
Okay. All right.
Your Honor, I'd like to move to adjourn the balance of the hearing to the 28th of March.
And I join in that
Okay.
request.
All right. Very, very good. Does everyone stipulate that we have in fact commenced the trial on the merits?
Yes, Your Honor.
Yeah.
Yeah.
Yes.
Right, okay, all right, so the request will be granted. The court does find that the trial has in fact commenced on the merits, and hereby recesses the trial until Tuesday, March the 28th at 9 a.m. All right, anything else before we adjourn? I think that's all we have on the docket.
Your Honor, I have one off docket question for you that maybe the attorneys might want to stick back so that we can talk about it.
Okay, all right, so then that will conclude our docket.